Sharia audit. A process of unbiased examination and evaluation of all operation and policies of organization according to Islamic law of business. Department of Sharia audit is Management, Administration, Human Resource, Social Responsibility, Marketing, Finance, Zakat. Term in the Sharia audit. Sharia audit will provide you the opportunity to increase your productivity, and business profit can be maximized by more and more productivity. Sharia audit will present the methods to minimize the business expenses and employees turnover, which is one of main factors of profit minimization. Sharia audit is the option to get pleasure of Allah SWT by avoiding His disobedience in our business, and this act will be the reason of barakah in our income and profit. Issue. A sleeping partner cannot get more profit more than his investment ratio according to Islamic law of business. It will be interest for him to take profit more than his investment ratio. The ration of loss can never exceed from investment ratio according to Islamic law of business. A person who has less investment cannot bear loss more than his investment. It will be interest FPR the person who has higher investment. There are many mistakes in sale department. Many salesperson do lie and make their transaction wrong according to Islamic law of business. Many organizations require from their employees to sign a service bond at time of hiring. This service bond is not allowed in Islamic law of business. Compensation of Sharia is not an extraordinary expenses. Investment in business. Contribution for knowledge and research. Sadqa-e Jariyah. Audit Oversight Board. The Securities Commission Malaysia has been given the power by Parliament to undertake these functions to promote and develop an effective and robust audit oversight framework in Malaysia and promote confidence in the quality and reliability of audited financial statements in Malaysia. Regulate auditor of public interest entities. Key responsibilities of the Audit Committee is to assess risk and control environment. Oversee financial reporting. Review conflict of interest situations and related party transaction. Evaluate audit process. Next we talk about whistleblower. What is whistleblower? Whistleblower is a person working within an organization who reports that organization misconduct. And a person can be a current or past employee. The misconduct can be a past act, ongoing, and in the planning stages. There have two types of whistleblower. 1. Internal whistleblower. This happen when a person report misconduct to another person within organization. 2. External whistleblower. This happen when person report misconduct to a person outside the organization such as law enforcement or media. Next we talk about the protection for the whistleblower. In Malaysia, whistleblower can be protected by Whistleblowers Protection Act 2010, Act 711, by MACC. There have a term that need to be followed by the informant, which is 1. The informant willing to be identified by MACC. 2. The informant personally attends and meets with MACC officers either in the office or at any place. 3. If the disclosure of improper behavior made by letter, email, phone calls, short message service, informant must reveal his identity and address of or the manner in which he can be contacted. Now we talk about the type of protection. In the Whistleblowers Protection Act 2010 there are some type of protection such as 1. The identity of the informant and the information provided is kept confidential and not to be disclosed to anybody, even during the trial in court. Accordance to Section 7(1)(a) under Whistleblowers Protection Act 2010. 2. Whistleblowers should not be liable to any civil action, criminal or disciplinary consequences of such disclosure. Accordance to Section 7(1)(b) under Whistleblowers Protection Act 2010. 3. Whistleblowers are protected from any act prejudicial to the outcome of the reaction disclosures have been made. Under Section 7(1)(c) Whistleblowers Protection Act 2010. 4. Protection is also given to those who have connection or relationship with the informant. Under Section 7(3) Whistleblowers Protection Act 2010.
Money laundering, yes, stealing. Money laundering is the process of transforming the profits of crime and corruption into ostensibly legitimate assets. An example of money laundering case is, let's see. Yes. The HSBC case, which is estimated to £5.57 million. Back in 2012, HSBC forfeited £1.2 billion for having inadequate money laundering controls. This followed a report published by the US Senate which alleged, amongst other things, that HSBC had supplied banking services and American dollars to some banks in Saudi Arabia in spite of their connections to terrorist financing. Dodge restrictions created to prevent transactions involving Iran, North Korea and other countries subject to international sanctions. HSBC US didn't treat its Mexican counterpart as high risk even though it has a problem with drug trafficking and money laundering. Control issues like these allow the laundering of an estimated £5.57 billion over at least 7 years. HSBC was able to enter a 5-year deferred prosecution agreement or DPA, which is essentially like being on probation. If the US government had pressed charges against HSBC, it could have lost its US dollar license.
Now we talk about transnational audits. What is transnational audit? It is an audit of financial statements which are relied upon outside the audited entity's home jurisdiction for the purpose of significant lending, investment or regulatory decisions. Transnational Auditors Committee. The IFAC Transnational Auditors Committee serves as the official link between IFAC and the Forum of Firms. It is broadly responsible for implementing and advancing the FOF objectives and operations, and plays a major role in encouraging members of the FOF to conduct high-quality international audits. By requiring the commitment to comply with certain international standards as a condition of membership. The TAC also supports audit quality by 1. Identifying audit practice issues and making recommendations to the appropriate standard-setting boards to review these issues as needed. 2. Providing a forum to discuss best practices in areas including quality control, auditing, independence, and training and continuing professional development. 3. Facilitating interaction among transnational firms, international regulators, and financial institutions with regard to audit quality, systems of quality control, and transparency of international networks. 4. Identifying qualified candidates to serve on the international standard-setting boards. Now we talk about the Forum of Firms or FOF or Forum. FOF is an independent association of international networks of firms that perform transnational audits. The objective of the Forum is to promote consistent and high-quality standards of financial reporting and auditing practices worldwide, bringing together firms that perform transnational audits and involving them more closely with IFAC's activities in audit and other assurance-related areas. Members of the FOF must demonstrate their commitment to adhere to and promote the consistent application of high-quality audit practices worldwide, as detailed in the FOF Constitution.